if you have doubt any. Haynes versus Harwood. Haynes versus Harwood. The unattended horse van of D startled running as some boys had thrown stones at the horse. The policeman who attempted to stop the horse was injured, held D liable. The contention that the throwing of stones was an intervening cause and hence D wasn't liable was rejected by the court. Next case law is Scott versus Stifford. इसको एक और नाम से जानते हैं, that is Squibb case. Squibb case के नाम से भी जानते हैं. A threw A threw a lightened squib into a crowd. Lightened squib को उसने crowd में फेंक दिया. It fell upon X. X के ऊपर गिर गया. X in order to prevent injury to himself threw it further. उसने further फेंक दिया. उसने injury नहीं prevent किया. उसने further उसको like this lit whatever the lighter squib उसने further फेंका. किस पे? It fell on Y. And Y in his turn did the same the thing and it fell on B, as result of which B lost one of his eye. B अपनी एक आँख खो बैठा. A was held to be. A was held liable to be. Person is presumed to intend the natural and probable consequence of his own act. Novus actus intervenes defense. Novus actus intervenes defense wasn't allowed. This wasn't allowed. Legal maxim. Legal maxim क्या है? Jure non remota causans proxima spectator. In this law, the immediate not the remote cause. In law, the immediate, not the remote cause of any event that is considered, the defendant has presumed to have intended the natural consequences but not the remote damage. Novus actus intervenes, new act intervening. New act intervening. Act and consequences are to be connected. दोनों कनेक्ट होने चाहिए. Directly and defendant will not be liable for novus actus intervenes and consequences thereof. अब मीनिंग क्या कहता है? No person can be made liable. कोई पर्सन लाइबल नहीं था ad infinitum for all the consequences which follow his wrongful act. A person is held responsible in law only for consequences which aren't remote. जो remote नहीं है. Re Polymus and Furnace Limited. In this case, D chartered peace vessels to carry or cargo which included petrol. Some cases were leaking and there were vapors of petrol. D's servant, while shifting cargo, negligently knocked at a plank which fell, rubbing the wood and got ignited. Entire vessel caught fire and was destroyed. यहाँ क्या था? Negligency थी. Negligency थी. That is why. Held D was liable. I told you why. Held D was liable for all the consequences, even though those could not reasonably have been anticipated. Next case law. Smith versus London and South Western Railway Company. Test was first upheld in this case. Railway company was negligent in allowing a heap of trimmings of hedges and grass near a railway line. Spark from the railway engine set fire to the material. Due to high wind, बहुत high wind था, the fire was carried to the plaintiff's cottage. किसकी cottage? Plaintiff cottage, which was burned. The defendants were held liable even though they could not have foreseen the loss of the cottage. Now, what is text of directness? Test of directness क्या होता है? The text of reasonable foresight was rejected in the year of 1921. In the case of Re Polymus and Furnace Limited, जो कि हमने पढ़ा ना, ऊपर देखा, Re Polymus and Furnace Limited, the person is liable only for the direct consequences. I mentioned above right away दैट पर्सन उसके लिए ही लाइबल होगा विच इज डायरेक्ट कॉन्सिक्वेंसेज ऑफ हिज wrongful act, whether he could have foreseen them or not, because consequences which directly follow a wrongful act aren't too remote. Now, test of reasonable foresights. Reasonable foresight से टेस्ट क्या होता है? Reasonable man. Which man? Reasonable man. Got it? A man of ordinary prudence. Reasonable man किसे कहते हैं? The man of ordinary prudence could have foreseen the consequences of a wrongful act. They aren't too remote. Test of probability. A man is responsible for the probable consequences of his act. The famous case law is Rigby versus Hewitt and Greenland versus Champlain. Doctrine of reasonable foreseeability was held that means defendant is only liable for consequences that a reasonable person placed in wrongdoer's circumstances could have seen. Further, we have the case laws Hughes versus Lord Advocate. Workers employed by the post office left a manhole in the road unattended. Before they left the site, they covered the manhole with a tarpaulin entrance. Tarpaulin entrance. इससे ही कवर करके चले गए थे and placed several paraffin lamps around it. The 8-year-old plaintiff, attracted by the lamps, was playing around the manhole along with another child. One of the lamps was knocked down, causing an explosion in the manhole. The explosion resulted in damage to the plaintiff. The defendants were held liable. यहाँ पे कौन लाइबल होगा? डिफेंडेंट्स लाइबल होगी. सेम थिंग इज रिटन इन हिंदी. आप इसका भी स्क्रीनशॉट ले सकते हैं. ओके. नाउ वैगन माउंट केस. वैगन माउंट केस. The test of directness was rejected in this case year 1960 and test of reasonable foreseeability of injury was reaffirmed. The wagon mount, an oil tanker vessel, was chartered by D at a distance P, had a wharf where some welding operations was going on. Due to the negligence of D's servant, oil split from the wagon mount. The oil split from the wagon mount spread over the wharf where P was making some welding operations. P's manager stopped his welding work, enquired D whether he could safely continue the welding. D assured no danger. B ने assurance दी कि कोई danger नहीं है. Later, molten metal from the wagon mound fell on the cotton waste, ignited and caused a great damage to the wharf and the equipments. The Privy Council in England, कहाँ केस था? England, held that D wasn't liable. D liable नहीं था. ठीक है. Liability arising out of a special relationship where the defendant stands on defendant stands to the wrongdoer in a relationship which makes him answerable for wrongs committed by the latter. Example, master and servant, principal and agent, guardian and ward, partners, guardian and ward जैसे हमने देखा भी, company and its directors भी है. Liability by abatement, where the defendant has induced another to commit a wrong. In such cases, those who abet the tortuous act are as much liable as tortfeasors themselves. Liability by rectification, where the defendant has authorized or ratified the particular wrongful act or omission. If one person commits a tort purporting to act on behalf of another, but without his authority and that another subsequently rectifies and assents to that act, he thereby becomes responsible for it. Further, we can see vicarious liability, including state liability. Vicarious liability can include state liability. Salmond, a jurist, famous jurist, Salmond. In general, a person is responsible only for his own acts, but there are exceptional cases, कौन से हैं? In which the law imposes on him vicarious responsibilities for the acts of others, however blameless himself. Liability for another's wrongful acts or omissions can arise in the following ways. अपन देख लिया क्या है, ठीक है. Public policy. Public policy. Pollock says, Pollock is also a jurist, I am answerable for the wrong of my servants or agents, not because he is authorized by me or personally represent, but because he is handling my affairs, I am bound to see that my affairs are conducted with due regard to the safety of others. Lord Pierce in Imperial Chemical Industries case, this is Antra case, the doctrine of vicarious liability has not grown from any clear logical or legal principle, but from social convenience and rough justice, the master having, presumably for his own benefit, employed the servants and being presumably better able to make good any damage which may occasionally result from the arrangement, is answerable to the world at large club, for all the torts committed by his servant within the scope of it. Qui facit per alium facit per se. He does he who does an act, he who does an act through another is deemed in law to do it himself. A person who puts another in his place to do a class of acts in his absence necessarily leaves him to determine according to circumstances that arise when an act of that class is to be done, and trust him for the manner in which it is done. Consequently, he is answerable for the wrongs of the person so entrusted. Justification of the for the maxim. Justification for the maxim. ठीक है? The difficulty in the way of proving actual authority and the better position of the master to meet the claim because of his large pocket and also ability to pass on the burden of liability through insurance. Principles on which vicarious liability is based. A. Respondent superior. Let the principal be liable. Let the superior be responsible. It puts the master in the same position as if he has done the act himself. This rule has its own in the legal presumption that all acts done by the servant in and about his master's business are done by the master's express or implied authority and are in the truth of the acts of the master. Now we have this case law. State Bank of India versus Shama Devi. State Bank of India versus Shama Devi. The court held that if a bank employee receives some cash and checks from his friend in his personal capacity without giving any proper receipt for depositing the same with the bank cannot be made liable if the employee misappropriates the cash and the checks. Next case law is Lloyd versus Grace Smith and Company. The managing clerk of a firm of solicitors defendants, while acting in the ordinary course of his business, committed a fraud against client, although the agent here had acted solely for his own personal benefit. The defendants were held liable because the agent was acting in the course of performance of his duties as an agent. Liability arising out of special relationships, principal and agent relationship. When the principal expressly or impliedly authorizes some act to be done, he is liable for such act of agent if the same has been done in the course of performance of his duties as an agent on the ground that it is principal who has selected the agent. Case law Limpus versus London General Omnibus Company. The employer may be liable even if he forbids his servant from doing certain act. The defendant's driver, in defiance of the express instruction not to race with other omnibuses, tried to obstruct a rival omnibus and thereby caused an accident. The case we see now above, omnibus wala case, the same case is this way. The driver had been engaged for driving, and the act done on his part was negligence driving because he was drunk. As I mentioned earlier, in spite of prohibition, the action was still in the course of the employment for which the masters were held liable. हिंदी में भी सेम थिंग लिखा हुआ है, आप इसका स्क्रीनशॉट ले सकते हैं फॉर द बेटर क्लैरिटी वंस यू कैन गो थ्रू विद दिस. Beard versus London General Omnibus Company. Yes, ma'am. When the servant act is altogether different from what has been authorized, the act is out of the course of his employment and the master will not be liable. यहाँ पे गौर करने वाली बात है. The focus, this thing should be focused at. जब authorized दो काम करने के लिए वो authorized हुआ है, the act जो वो काम कर रहा है is out of the course of employment. उसका काम ही नहीं है. For the same, जैसे at the end of the journey, journey driver of a bus went to take his dinner. During his temporary absence, the conductor drove the bus in order to turn it round to make it ready for the next journey and negligently caused an accident. Look, since driving wasn't kind of act that conductor was authorized to do, the conductor was acting out of the course of employment for which the master was held not liable. इसके लिए तो नहीं master liable होगा. Got it? When the managing clerk of a firm of solicitors, while attending a client on behalf of the firm, sorry, fraudulently got the property of client transferred in his own name, the act was held to be done in the course of his employment and the firm was held liable. The case law is Lloyd versus Grace Smith and Company. Lloyd versus Grace Smith and Company. अभी हमने देखा क्या कौन सा केस था, दिस स्टेट बैंक ऑफ इंडिया वर्सेस श्यामा देवी का केस था, in which if a customer of the bank gives some amount or check to the bank employee in the capacity of a friend for being deposited in the account without obtaining any receipt for the same, the bank employee isn't deemed to be acting within the scope of his employment, and if the misappropriates the amount, the bank will not be liable. Bank liable नहीं होगा उस केस में.